The following is a presentation prepared by Judge Stephen E. Brown to explain the current small claims process in Grays Harbor County District Court, Washington State as of 2012. The purpose is to provide case participants and others the information needed when involved with a small claims case in Grays Harbor County. State Law, Chapter 12.40 of the Revised Code of Washington creates a small claims department as a part of the district court in each of Washington's 39 counties. If you are involved in a small claims case in a county other than Grays Harbor, please consult with the small claims court in that county for the procedure specific to that court. A small claims court judge may use this script or one similar at the beginning of case participants' first appearance in small claims court.
I'm Judge Steve Brown. This is the return calendar for small claims cases filed in Grays Harbor County District Court, which means that this may be your first appearance in small claims court. Before we deal with each case on our calendar today, I'm going to talk to you about our small claims court process so that you will have at least some idea of what to expect today and in the future. Most of this information is also available in our small claims court pamphlet located in the court's pamphlet rack at our customer counter and online at Grays Harbor County's website. The first appearance in our small claims court is called the return calendar. This is where we find out whether or not a case is ready to go forward to trial. The person or business that filed the claim, the person who is doing the suing, is referred to as the plaintiff. The person or business responding to the claim, the person being sued, is referred to as the defendant. The person who determines court procedures, presides over the trial, and makes decisions is called the judge. In court, the judge may refer to you by your name or as the plaintiff or the defendant, as the case may be. The judge should be addressed as Judge or Your Honor. Today on our return calendar, the judge will be looking for three things that are necessary for a case to go forward. 1. Proof of service. 2. Appearance of the defendant. And 3. Whether the defendant disputes all or any part of the plaintiff's claim. After filing the claim with the court, the plaintiff's responsibility is to deliver a copy of the notice of claim to the defendant, either in person or by certified mail with a signed return receipt. The legal phrase for this is called service of process. The person who delivers the claim is called a process server. The plaintiff's responsibility is to see to it that written proof of having delivered or mailed the claim to the defendant is filed with the court on the appropriate form. Our form is called a return of service form. Similar forms may be called an affidavit of service. All such forms must be signed by the person who made the delivery or mailing, the process server, under oath or affirmation. When a defendant receives a small claims notice of claim, either from a process server or through certified mail, the defendant is required to appear in person at the date and time set in the notice of claim. This would be on one of our return calendars. In some cases, upon the defendant's written request, the judge may permit the defendant to appear in writing, by letter or some other signed document. If the plaintiff has filed proof of service and the defendant does not appear, the judge will place the plaintiff under oath and have the plaintiff tell the judge about the claim. If the facts about your claim are sufficient under the law, the judge will give you an immediate decision, called a judgment by default, and the clerk will provide you with a copy at our customer service window. If the defendant is present, the judge will ask the defendant if all or any part of the plaintiff's claim is disputed. If the defendant agrees to the claim, does not dispute it, then the judge will make an immediate decision called a judgment, awarding the plaintiff the amount requested in the notice of claim. The judge will ask the defendant if the amount can be paid immediately. If the defendant cannot pay in full, the defendant can ask the judge to set up a payment plan. The court will provide each side a copy of the judgment and payment plan. Before a case will be set for a trial, the plaintiff and defendant must attend a mediation session. Mediation appointments will usually be made on the return calendar day with representatives of the Dispute Resolution Center. Failure to attend a scheduled mediation session will result in the court entering a judgment adverse to you. This means that if the plaintiff fails to appear for mediation, the case will be dismissed. If the defendant fails to appear, the plaintiff will return to court on another return day, to apply for a judgment by default in the same manner as if the defendant failed to appear on the return calendar. If the case is not resolved through mediation, the judge will authorize the clerk to set the case for a trial, which will usually be within 30 to 60 days. If your case is not resolved through mediation and the court sets a trial date, you should prepare your case for trial. Organize your documents, receipts, pictures, and other items. Practice presenting your case. Tell your story. The judge at trial will expect you to be prepared and ready. If a witness cannot appear personally for trial, you should obtain a signed written statement from each such witness. You should make one set of copies of your documentation for the judge and another set for the other side. Remember at trial that you are there to present your case to the judge, not to argue with the other side. The judge will be interested in the who, what, where, when, how, and why of your case. Getting emotional in court generally is not helpful to your case. The judge will listen to each side along with any witnesses called by each. Documents, pictures, receipts, estimates, and any other items should be presented to the judge so that they may be included as part of the evidence in your case. Evidence is a legal term. The testimony of the witnesses, including the plaintiff and the defendant, and the documents, pictures, and other items presented to the judge make up the evidence in a case. The judge may ask questions of any witness, including the plaintiff and the defendant. After all the evidence is presented, the judge will inform you of the decision or judgment in your case. The judgment will be in writing, and a copy will be provided. As stated earlier, the judge can order a payment plan to provide that the judgment be paid in regular monthly payments. The advantage to the plaintiff is that the judgment will be paid voluntarily without the necessity of incurring additional collection expenses. The advantage to the defendant is that the judgment can be paid over a reasonable period of time, and as long as the defendant follows the payment plan, the plaintiff is prohibited from enforcement of the judgment through legal process, such as garnishment of wages or bank accounts or a share of sale of property. A small claims judgment cannot be enforced for 30 days, which is the time either party has to file an appeal. An appeal of a small claims case is heard in the Superior Court and is based on the record of the trial held here in Small Claims Court. This is another reason for you to prepare for trial. An appeal is a court hearing in the Superior Court based on the evidence presented in Small Claims Court. An appeal is not another trial where you get to start all over. No appeal is allowed where the amount claimed was less than $250. The party who files a claim or counterclaim cannot appeal unless the amount claimed exceeds $1,000. To pursue an appeal, you will need to obtain the necessary information and forms from the court office. Follow the steps set forth in the appeal information. A notice of appeal must be filed with the court within 30 days of the entry of the judgment, or you will lose your right to appeal. I'd like to leave you with some final comments regarding our mandatory mediation rule for small claims cases. Mediation works. At least 75% of our disputed cases are resolved through mediation. Mediation is easy. The mediator assigned to your case will explain the mediation process to you simply and clearly. Mediation can lead to better outcomes. You can agree to do things such as make repairs, return property, or even to apologize. At trial, a judge is limited to the issue of whether or not to award a judgment for the payment of money. People who reach a mutual agreement are part of the decision, and they tend to be satisfied with the process and the outcome. Satisfied parties are more likely to carry out any obligations agreed to. Mediation is comprehensive. Emotional factors can be the primary reason for making a particular choice or decision. Emotional factors can be valued in the mediation process. On the other hand, in a trial before a judge, things like anger or outrage or qualities of being a good person are usually not valued at all or very little. In fact, some emotional issues can reduce a person's ability to present all the relevant information to a judge during a trial. Mediation will better prepare you for your trial. Even if your case is not able to be resolved through mediation, you will be able to learn all of the information the other side thinks is important. This will help you to respond to the other side's presentation at trial. You may also benefit from the practice of explaining your side in front of someone who knows nothing about it. This can assist you in concentrating on the important facts of your case when it comes time to tell your side to the judge. Judge Copeland and I hope this presentation will assist you in managing your claim or defense and improve your understanding of our small claims process. If you have any questions about the information I covered or something else related to your case, please ask the judge when your individual case is called on today's calendar. Thank you very much for your attention.